Hi, everyone. I'm Beverly Price, and you're listening to the Divorce Coalition Live show. This is a show designed for divorce professionals about how the divorce process can be improved to improve the divorce experience for domestic abuse survivors. Much research says that the divorce experience for these survivors actually creates a second trauma experience for them in addition to the trauma from their abusive relationship. I'm the CEO and executive director of the Divorce Coalition and certified divorce coach at Her Empowered Divorce. The Divorce Coalition is a nonprofit organization dedicated to increasing education and awareness of divorce professionals, along with process change to create a more supportive and less traumatic experience. We have united top podcast hosts, divorce and domestic abuse professionals to create systematic change in the process for domestic abuse victims. With expert guests, practical advice, and enlightening conversations, you'll find that knowledge is power in creating change in the world. So, in today's world of divorce, more and more couples have to deal with court in regard to domestic abuse. So the question becomes, what do attorneys need to know, divorce attorneys need to know in this experience? So who better to help shape this conversation than a retired judge with hands-on experience? My guest today is Larry Jones. He is a fabulous guest who also has years of experience being a judge and consulting on domestic abuse situations. Hi, Larry. How are you doing?
Very good, Beverly, and thank you very much for having me this morning. It's a pleasure to be here.
Oh, it's awesome to have you. So, can you tell the audience a little bit more about yourself?
Sure. I was a domestic violence and divorce judge in New Jersey, in the Superior Court of New Jersey for many years. I retired from public service in 2017. After retiring from the bench, I started teaching at the university level. I taught at Monmouth University in New Jersey, where we developed a whole course for undergraduate students on domestic violence law and policy, where I learned more during those years, actually, than in my years in practice, listening to the students and their perceptions of domestic violence and dating violence. And I've relocated with my wife, Joni, out to New Mexico, where we are right now. So greetings from the land of enchantment. And
Absolutely.
we're doing work in the domestic violence realm out here as well. So again, it's a pleasure being with you and your listeners, Beverly, today.
We are so grateful for your presence and your knowledge in this topic. So, I think that, with our topic, what divorce professionals should know about judges and how to handle divorce with abuse. Let's start off with, how do you see domestic abuse? And I use that word, abuse, meaning all forms of abuse, not just the physical violence. How does it relate to divorce? And what are the kinds of overview should divorce professionals know?
Well, first of all, obviously we have 50 states and plus territories, and each jurisdiction may have its own specific domestic violence statute and or case law that addresses domestic violence. So if we're talking to an audience of divorce professionals, meaning attorneys, and there are other divorce professionals besides attorneys, obviously, counselors and
Yes.
things like that. But if we're talking specifically with attorneys, the most obvious point for starters is to really know the substantive law of your jurisdiction, because it can
Gotcha.
very much differ from state to state in terms of what is domestic violence, what's not domestic violence, and also the procedures which are involved. And sometimes they could vary within a state from district to district or court to court. So it's very important to kind of be familiar with the procedures which are utilized in a particular court where one may be appearing. Some people, it's the first time appearing in a particular court, and they know the client, that type of thing, and they're going in, but they haven't had a lot of experience in that court or with that particular judge, or how domestic violence procedures are really handled in that particular court. So it's certainly helpful to the client if the attorney is familiarized in that context. Obviously, knowing the law of domestic violence becomes very important for preparing a client a part of a large part of an attorney's responsibility, I would suggest, is not so much what takes place in the courtroom at the trial, but all the work leading up to the preparation of the trial.
Yes. Mm-hmm.
Not only preparing yourself as an attorney, but preparing the client, because sometimes it's their first time in a court and they could be overwhelmed, they could be nervous, they could forget things. And so preparing a client is similar to like preparing a football team for the Super Bowl. You don't just show up, you have to practice and, you know, really know the lay of the land, so to speak. So that becomes important as well.
If and is there, what should the other divorce professionals know, other, you know, aside from also perhaps being familiar with the laws in their state at a high level? Are there other things that coaches and therapists and mediators and real estate professionals, any thoughts on anything they should be aware of?
Well, you just named a series of very important professionals, but they all have very distinct roles. They don't always overlap. It's certainly helpful if there are various professionals involved in a case involving someone who has suffered domestic violence, for everyone to kind of be on the same page, so to speak. But nonetheless, their roles are very different. So a role of a mediator, for example, would be very different than the role of an attorney, even if the mediator happens to also be an attorney, because in the role of a mediator, you're neutral.
Right.
You're not representing either side. You can't really take sides when you're a mediator. Whereas when you're an attorney advocating for a client, whether they've been through domestic violence or not, your duty is solely and exclusively towards that client and watching out for their best interests. A mediator really can't take sides in that respect. The therapist, obviously, their role is more in the health-related, mental health-related, or other health-related realms. In dealing with the client. And then obviously you're talking about, you mentioned real estate professionals and things like that. They really wouldn't get too involved in the issues of domestic violence, one would think, unless there are warning signs that somebody is acting in a way where they are being oppressed in some fashion, or under duress, or under the influence of somebody, or not really exercising independent judgment. They may not be ready to make certain decisions at a certain point, in which case, you know, if there are warning signs of that, there's, you know, different things you may elect to do in that situation. Because it's very important in divorce for the person who's getting divorced, whatever decisions they're making, for those to be their independent decisions and not anything that's forced upon them in any fashion due to duress.
Absolutely. That is so important. I like to think of many of the professionals as almost early warning systems in that regard.
Yeah.
So, in some states, I know that family court, or divorce court, if you will, could be very different than domestic violence court. You may have family court, criminal court. You may have family court that does handle orders of protection. How does that affect a divorce professional's role?
Well, first of all, for those who don't have a lot of experience, those attorneys who don't have a lot of experience in domestic violence, sometimes there's a tendency to think that that's a criminal act, and it can be, but it's not always a criminal act depending on what court you're in. And there are different rules and different considerations. So, for example, if you're in a jurisdiction where there's a domestic violence statute and it's handled by the family court, you could very easily have a situation where one act of domestic violence results in two different actions taking place in two different courts, both arising from the same activity. So, for example, let's say in a hypothetical case, you have a husband and wife, and just in this hypothetical, let's say the husband strikes the wife in the middle of a fight. That's clearly an assault, right? As a result of that assault, and let's say the wife calls the police, there could be two separate actions arising, at least two separate actions arising from that one incident. One might be a criminal charge brought by the state for assault, because assault is usually a criminal action. But on top of that, there could be a domestic violence complaint in the family court, indicating that the act of assault is an act that justifies, or potentially justifies, depending on the situation, the entry of a restraining order. Now,
Okay.
if you have the same action resulting in two separate proceedings in two different courts, there could be drastic differences in how those two cases are presented. In the criminal system, for example, the defendant has a constitutional right to remain silent under the Fifth Amendment. They don't have to testify. That might not be the case in what might be a civil action in the domestic violence court, where if someone refuses to testify, there could potentially be what's known as an adverse inference against that person. That's number one. Number
What
two,
is an adverse inference?
an adverse inference means that if somebody refuses to testify for example, in a civil case, the court can make an adverse inference against them, meaning that their refusal to testify means that it could be held against them, that they had
Gotcha.
the opportunity to say what they had to say and they refused to do so in certain instances. In the criminal system, there can be no adverse inference against someone refusing to take the stand or choosing not to take the stand. So for those who see criminal cases on TV or in the movies, someone says, I elect my Fifth Amendment right not to testify, and the judge instructs the jury that the jury is not allowed to infer anything negative about their refusal to testify, because in the criminal case, the state who brings the charges, because it's State versus Jones or State versus Smith rather than Smith versus Smith or Jones versus Jones, they have an obligation under the Constitution to prove every element of the offense in this hypothetical assault by the standard of beyond a reasonable doubt. In the civil system, it's not necessarily the same way. And so when we talk about burdens of proof in the criminal system, as I just indicated, it's beyond a reasonable doubt. That's a very high standard. In the civil system, it's a much lower standard, preponderance of the evidence standard, which means basically more likely than not what occurred. You don't have to prove your case generally beyond a reasonable doubt. So for those, for example, who remember the domestic violence and homicide case with O.J. Simpson, if you recall, there were two separate cases that arose from the same action. One was a criminal case and one was a civil case. In the criminal case, O.J. Simpson was found not guilty because the jury in that case found that the state of California did not prove guilt beyond a reasonable doubt. In the civil case, O.J. Simpson lost. And the jury came back and said that the plaintiff in that case, who was not the state of California, but the families of the victims, that they proved that he had committed these acts, homicide in this particular case, by the preponderance of the evidence standard, by the much lower standard. Also, O.J. Simpson, if he was not required to testify in the criminal case, or in the civil case, if he did not testify, there could have potentially been an adverse inference against him, and he did testify in that case, as I recall. And so you had two different verdicts arising from the same exact situation. So that could happen in any domestic violence case where you have a case pending in the family court for domestic violence with a lower burden of proof, and a criminal case where the state has to prove its case beyond a reasonable doubt. So there are major differences between the two types of cases, even though they involve potentially the same facts.
Gotcha. If a professional, but particularly an attorney or mediator, doesn't have domestic abuse experience, what's available to them to gain more experience? I assume they could go into and listen to another court with another attorney leading the case, but what educational opportunities exist?
Well, first of all, when you reference going in and watching a case, if you've never done one before, that could be very valuable in terms of learning and seeing firsthand how a domestic violence case, at least procedurally, may take place. But as I referenced before, at least in my view, a huge part of the attorney's job is what takes place before the actual trial. So if you are dealing with a client who has suffered domestic abuse and you're counseling them and dealing with them and prepping them and listening to them, it can be very helpful to have an ongoing educational awareness of what domestic violence is and the potential consequences of domestic violence on someone who has been abused, so that you have a better working relationship potentially with the client. So nowadays, there's tons of educational information out there online through very reputable nonprofit organizations, national organizations, state organizations, There's probably seminars available at least weekly, if not more than that, for anybody who's interested in that area. And it's an ongoing work in progress to constantly familiarize yourself not only with the law of domestic violence, but the potential ramifications, financial, emotional, physical, on someone who has suffered domestic violence. So you're potentially more attuned to what the client's needs may be in a given situation. Every case is its own entity, obviously. Every person is unique, but having ongoing education in that area is very important. And that's also important when you're mediating, because in some states, first of all, you're not even allowed in some states to mediate when there is a restraining order in place. You have to find out what the laws are in each state. Some states, for example, in New Jersey, where I practiced for many years and sat as a judge, they set up this mediation program where they allow economic mediation, but only economic mediation through the court, not on issues that are non-economic, like custody or parenting time. There's a restraining order. And the mediator must go through a special training program specifically for addressing issues with a person who has suffered through domestic violence, so that they are attuned to things such as voluntariness or non-voluntariness, coercion, things of that nature, things which become very important in the realm of domestic violence. So it's very important to know what the laws are of your state in terms of whether you can or cannot mediate when there is a restraining order in place. And if you are allowed, what are the criteria? And because otherwise you don't want to be in a situation where, for example, you just assume it's okay to mediate. You find out after the fact that there was a law or policy in your jurisdiction against that.
Gotcha. Absolutely. So I think we talked a little bit about how you prepare, what to consider. The $1,000 question is, what do judges consider in domestic violence and domestic abuse cases?
Sure. Assuming we're talking about a domestic violence case in a domestic violence court and not necessarily in the criminal court.
Right.
Because the other, I pointed out a couple of distinctions between those two types of forums, but another large one is in the criminal court, you might have a jury, where we'll almost never have that in the family court. It will be what's called a bench trial, which is decided by a judge. So, for example, when I sat in family court, domestic violence court in New Jersey, there was never a jury. I was deciding the case, but both administering the case and deciding the case at the same time. So in terms of, I can't speak for every judge out there, or I can't speak for every jurisdiction, but I can tell you in general from my years of experience, kind of what I learned and how it works. First of all, every domestic violence statute has criteria to it. Okay. And so, for example, in New Jersey, there was a two-part test. They called it a two-pronged test, which judges were required to decide in determining whether to issue or not issue a restraining order. And it was very important for lawyers who were presenting the case to be familiar with that as well, because otherwise, if the lawyer wasn't familiar with it, you could potentially lose the case when it could have been won because you didn't follow the appropriate evidentiary protocol in terms of what needed to be proven by a preponderance of the evidence or otherwise. So in New Jersey, it was a two-pronged test. Number one, prong one, did an act of domestic violence occur? And within the statute, there were definitions of domestic violence. So assault becomes an obvious one. There's harassment, coercion, the different types of terroristic threats, different types of elements of offenses. So the first prong is, did an offense occur that fits within the domestic violence statute in your jurisdiction? Okay. And the second, in New Jersey at least, was even if an act occurred, is it necessary, reasonably necessary, for a protective order to be entered in order to protect the victim? Because sometimes you could have theoretically a case where an act may have occurred in prong one, but the evidence doesn't warrant prong two. I'll just give you a hypothetical example. Let's say somebody says that they were being verbally harassed, and not just a disagreement, but it reached a point of really, domestic violence, of constant harassment by their partner. So that might meet prong one, depending on how the evidence came in. But let's say the evidence is further that the last time that happened was a year ago, and the parties are still living together, and they're going on to the social media site, which shows they're always going out together, and now they've had an argument a year later because they had an argument over something. The fact that an prior act of domestic violence occurred doesn't automatically mean that the court's going to find it's necessary now, a year later, after they've kind of reconciled, to enter a restraining order at that point, as opposed to a situation where, and that's just a hypothetical, but as opposed to a situation where, for example, let's say somebody was abused the day before, and it was at the time they were getting divorced, because this is about divorce, right? And so sometimes domestic violence spikes when people are separating, even if there was no history beforehand of domestic violence. So you could, in that type of case, it might be more predictable that both prongs of the test for a domestic violence restraining order might be entered. So there was a two-prong test, and I know, I in my experience, I noticed that many times attorneys would come in, and they weren't addressing that two-prong test at all. They were just putting their client on the stand. It almost looked sometimes like they had never spoken with the client before walking into the courtroom.
Exactly.
You could almost tell that because there was a disconnect between the attorney's questions to their own client and the client's response. Like the client was sometimes caught off guard by the attorney's own questions. And so, and those questions were not necessarily geared towards proving the two-prong test.
Gotcha.
So it would become difficult sometimes. You know, an experienced attorney or one who, you know, did their homework would potentially walk their client in the privacy of their law office or otherwise, walk their client through the two prongs, basically let the client know in advance at least some ideas to what the questions are going to be. That's not putting answers in the client's mouth. That's just prepping the client for what's coming, so they're not additionally overwhelmed by not only what's going on in this courtroom and having to be in this public place and everything, but also they kind of know what the questions are. Because sometimes people come into court and they could be the smartest person and the most educated person and most accomplished person in the world, and they come into court and they freeze because it's overwhelming sometimes, especially when you're going through something like a divorce, domestic violence. These things are very emotionally devastating. So I would see people from, you know, doctors, lawyers, people highly educated, highly successful, and on the stand, it was obvious they were unprepared. It was just obvious they were unprepared. And so even if an attorney takes just a couple of hours or sometimes more, depending on the situation, to at least help prepare the client for what they're going to expect, there's a more logical and less surprising to the client a way of presenting a case. And if it matches up with the elements, procedurally matches up with what what a judge needs to decide on a case, it's helpful to the court. That doesn't mean that the judge is always going to decide in favor of the person who filed the domestic violence complaint, because just like with a mediator, a judge must be neutral. Both sides have an opportunity, the plaintiff and the defendant, to present their case. And then the court very often has to make a decision between kind of a one person one said versus person two said situation, based on demeanor and you know, credibility, things of that nature. But if you don't present the elements of the offense in some logical order, you make it even more difficult to prevail or for a judge to rule in your favor, because if you haven't met the elements that are necessary for a restraining order, you might lose a case that you could have otherwise won.
Absolutely. So when you talk about, you know, meeting some of the elements that certainly I'm sure involves proof that abuse occurs, what kind of information does that attorney need, maybe from the client, to be able to satisfy some of those requirements? What should a survivor do?
Okay. Different cases, you know, have different fact patterns, obviously. So, for example, in an extreme case, you might have a situation where one person has physically assaulted the other person in public, and there's video cameras, or someone has it on a cell phone or whatever. There's a video of it or audio. And so those types of things, that type of evidence clearly should be considered as relevant to potentially supply to the court. And we could talk about that more in a second. But the reality is, with domestic violence, by its very nature, a lot of times the abuse takes place in private. It doesn't take place in public by its very nature.
It's in hiding,
Sometimes someone who's abusive presents the complete opposite in their public persona at work or with
Yep.
friends or in a courtroom, and they come in sometimes and they're all, they're calm as can be. And there's a way which sometimes people who are abusive present. They don't necessarily present the same way to the rest of the world as they do to the partner they are abusing. So very often, and also very often takes place in the house, and very often takes place at night where there are no other witnesses around except maybe
Right.
children or something like that. And so in those types of cases, even though you don't have necessarily evidence, videotaped evidence or photographic evidence or things like that, you might not have that. You can still prevail on the case on your credibility versus the other side's credibility. When I say your credibility, I'm talking about the one who has been abused, the survivor. And so a lot of cases, for example, when I was on the bench, there was no extrinsic evidence of anything. It was just one person's word versus another. And it doesn't mean in those situations that the defendant always wins. It means that it's an issue of who the court finds to be more credible, considering things like the person's demeanor, considering things like the person's body language, considering things like the person's, like the logic and consistency of what they're saying. Right. This is why it's so important in a lot of these cases for there to be preparation in advance.
Yeah.
Because if you come in and you're not prepared and you just say, I'm just going to tell the truth or my truth, you could very easily be because of nerves or otherwise, lose track of what your thoughts are, even on what they call direct examination, which is when you present your case. And then to make it worse, if you're being cross-examined by the other side's attorney and you're not prepared for that, you could be taken apart, even though, verbally, even though everything you're saying is 100% true. Mm-hmm. And it just may not present the same way in terms of credibility in a person one versus person two situation. So when someone is a little more prepared for what they're walking into, there's a better chance they will be able to present in a more effective way. It's just like when you go on a job interview, if you just walk in and I'm just going to talk and you don't do any preparation, you don't know anything about who you're interviewing with or where you're interviewing or anything like that, it might work out. It's possible it might work out, but it's also very possible you might be doing yourself a disservice because you didn't prepare. So things like, for example, when you talk about preparing for a domestic violence case, basically taking the time to write out in conjunction with your attorney, so you're prepared, and the attorney could request that the client write this out in attorney-client communications for preparation. Number one, your version of what happened. What is what's known as the predicate act of domestic violence? What is the specific recent act that brings you to the court now? Number two, why you believe you need a restraining order. So if you're asked anything about that two-prong test or some form of that in any jurisdiction, you're prepared for it. And you can give an answer without having to scramble during a time when you may be, emotionally, really not prepared to think of things on the spot, perhaps. And number three, and this becomes very important in domestic violence, is what the prior history has been. Because certain predicate acts might rise to the level of domestic violence given one history and might not necessarily be considered domestic violence given another history. It obviously, an assault, a punch to the jaw is domestic violence, and you would think in any circumstance. But when you go back to the example about, for example, verbal harassment or verbal threats, the background can really, in some cases, make a difference in whether a court is going to determine whether that justifies a restraining order or not. So, for example, if somebody says, during a fight, I could just hit you right now, and they've been married for 25 years, and there's never been any allegation of any prior, anything even remotely close to that. Not to say you couldn't get a restraining order on that, but it's possible the defendant in that case might say, I was just saying that because I was angry, and she knows I didn't mean that because there's 25 years of a history. There's no problem here. On the other hand, if somebody says something like that and there's been a history of hitting or threatening to hit or abusive conduct, then the threat that comes with those words may become more elevated, and it may be something which a judge says is enough to grant the restraining order in that particular case. So in both of those hypotheticals, you never quite know if the court will or will not grant the restraining order, because they have to consider both sides, not just one side. They have to consider
Right.
prior to look at both sides. But the prior history is extremely relevant, given the nature of domestic violence itself. We know from studies of domestic violence that it's something which recurs in cycles. They call it the cycle of domestic violence and the power and control wheel, and all of these studies taking place. Dr. Lenore Walker's book on the battered woman, etc. And so if there's a prior history and the court believes and finds you credible about the prior history, the way you've described it, then the predicate act that might not be so clear cut in terms of whether it's domestic violence or not, might be enough to persuade a court to grant a restraining order to protect the person from escalating abuse, as opposed to a situation where there's no history of violence and the parties have been together for years, and it was a verbal argument rather than, a physical, assault or something of that nature. So you don't have to be physical to commit domestic violence. You can have verbal harassment in certain instances. You can have terroristic threats. You can have stalking. You can have things which are not a physical assault, and they still can be domestic violence if the jurisdiction recognizes it. But it's still important to give the court a flavor for the entire history of violence, if any, between the parties.
That is so important. And one of the things that I suggest to my clients is document, document, document.
Right.
But if they're in an active situation, I suggest that they keep that documentation offsite, away from the abuser, because if the abuser sees that, it could escalate the current violence.
Well, that's really important point, Beverly. Yeah. That's really important, because a lot of times what an abuser may do is bug the house, is put tabs on what's going on the computer, which you can see even remotely with key strikes, with phone bugging and things like that. So, quite frankly, a lot of organizations, domestic violence organizations, they have a thing on their website where someone's going on, they have a red button where you can immediately go off.
We have that on the coalition page. Yeah.
Right. It's probably a good idea in general if you're communicating with an attorney during a divorce where domestic violence has been an issue, or even if it hasn't been an issue, especially if you're still residing with the person, to not communicate on any laptop or any device where there could be a common thread where the other side can access in. If it's a common account, that can happen that way. And so sometimes you open up a separate account or get a separate phone or whatever it may be, so that those communications are not compromised. There have been lots of cases of that happening, based on my reading, by the way, of people who are, they're getting all the information, everything you're discussing with your attorney, because, basically you're being bugged, essentially. And so you got to be really careful as far as that's concerned. And the other thing to be careful about, among many things, but another one is who you're talking to. A lot of times, people they're telling everything to their friend, or some common acquaintance.
Telling the abuser.
Yeah. I mean, that happens. And then, well, you weren't allowed to tell them that. Well, there's no law that says anyone has to keep your secrets, other than perhaps an attorney in a confidential relationship. So you got to be really careful about who you're sharing information with, quite frankly. But I just want to go back for a second in talking about prepping for the domestic violence case when you're talking about attorneys. And each attorney has their own way of operating. I understand that. But just by way of suggestion, if to attorneys who are doing perhaps one of their first domestic violence cases or one of their early ones, it's not necessarily a bad idea to bring the client in at least a few days before the domestic violence case takes place and give them some written homework. And the written homework, not just verbal, because writing, and it's been shown this over and over again in studies, that when people write things down, they're more clear on it. And also you kind of recall things better. And also it helps the attorney, because if the attorney asks the client, say, I'd like you to get back to me by tomorrow. It's just attorney-client communication, so it's all confidential. Give me your narrative of really at least 3 points. You could have more than 3 points. But at the very least, number one, describe the act of domestic violence, the predicate act. Number two, what you want to tell the court as to why you think you need a restraining order, why it's important. And number three, what's the prior history? Concentrating, I would suggest for the most part, on the most severe acts of domestic violence that you're alleging, if there are any, and approximately when they occurred. Now, what does that do? It first of all gives the client some direction on what they can go home and start getting their thoughts together, instead of sometimes there's a lot of thoughts. We all have thoughts that are all over the place sometimes, but it's when you try to put them down on a piece of paper, takes a little bit of effort to do that. Number two, think about how that helps the attorney. Now the attorney, attorney's usually busy. They got, more than one client. And if you had that piece of paper in advance, it would give you the opportunity to review it, to go through it and say, well, what here is really important or really material to the case rather than just everything. And to be able to speak again with the client if there's any ambiguity in terms of the information they're providing, instead of the attorney just saying, well, I'll meet you at the courthouse, and hearing all this stuff for the first time on the stand without any degree of preparation or basically focusing in on the limited time you have. In most cases, you don't have indefinite time to concentrate on what are the most important elements of your case. And then the other thing is, a lot of times people come in, they have all their evidence on a cell phone. These days, a cell phone is like having a file cabinet in your pocket, right? And people come in and oh, you should see all these texts and this video, and I've got all this evidence, but the attorney hasn't looked at it until they're in court. So I would see sometimes from the bench, someone would say, well, I want to play a tape now. And okay, you want to play a tape? Fine. And then the tape sometimes is not at all relevant to what's going on. Sometimes it actually hurts the client because it's a tape of the client screaming at the other side sometimes. And it's obvious. It's just obvious the attorney is not taking the time to review it first and make an informed decision and give the client their professional judgment as to what, if any, portion of that is even relevant to the case. And then you want to have it ready because if you just have a cell phone, remember, the other side has a right to see or hear the evidence. The court has a right. There's a restraining order, so you can't have contact. So you'd be slowing down the case every time you're relying on a cell phone to be passed around the courtroom for any evidence that you might have in terms of the domestic violence or the relief that you're seeking. So having that organized in advance, taking the time to have it ready, having some maybe having documents printed out in triplicate, one for you, one for the other side, one for the court. You keep the case moving instead of slowing it down. Most of the time in domestic violence court, I had more than one case waiting in the courtroom. Sometimes they'd have 20 or 30. And, something was slowed down because the attorney wasn't prepared. It prevents the case from orderly moving towards a disposition in some cases.
Absolutely. Larry, this is so valuable. I have so many more questions. I think I'm going to need to bring you back to talk about how restraining orders relate to custody and support and division of assets. But there's one more question. I interviewed a judge a retired judge, about his opinion of domestic violence in court. And his response to me was he didn't know many judges that took domestic violence seriously because there's so much false reporting. Can you share your thoughts on that?
Well, I can't speak for any other judge, but I can say in general, both myself and the judges I worked with in New Jersey, they took domestic violence very seriously. You have to take it seriously,
right?
And because otherwise it can obviously get worse. And so different states, as I indicated at the outset, have different laws concerning domestic violence and different remedies concerning domestic violence. And that's important to know too. For example, in New Jersey, when you get a restraining order, that restraining order could be, in some cases, forever. Whereas in other states, they time out after a certain period of time, unless the survivor goes and seeks an extension and shows cause.
Exactly.
Very important to know what the laws are in the state as far as that's concerned. But in terms of general policy, I would be very surprised. I don't think I've ever met a sitting judge who did not take domestic violence seriously. You have to in this day and age. It's not like it was, 100 years ago where there's not a lot of education in this area. And judges are required in general to have ongoing education in this area for this very reason, that you can't just put it on the side or not take it seriously. And to the extent that there's a possibility that someone's making a false charge in a certain case, that's true in every area of the law, not just domestic violence. In any case, there could always be somebody who's not telling the truth in a landlord-tenant matter, in a civil matter, in a criminal matter, in a bankruptcy matter. With domestic violence, obviously the risks become greater if somebody is not telling the truth on either side.
Right.
But that's where, courts, they try to do the best they can and in terms of listening to the testimony and considering the evidence. And, nobody's perfect and nobody's going to get every case absolutely right. And some people are able to, on either side could say something that's not true and the court could rely on it. But that being the case, in terms of taking domestic violence seriously, the fact that jurisdictions have domestic violence courts dedicated towards domestic violence, that alone indicates that it's taken seriously or should be taken seriously. So I don't know if that's what that whatever is that other judge said, if that's what he said, I don't agree with that.
Okay. Thank you very much for that. This has just been incredible. And I do want to have you back to talk more. I'd also like to share that your wife, Joni, in our next episode is going to talk more about how survivors wish the divorce professionals treated them and handled them through the divorce with domestic violence. And I think that is incredibly important, again, to prevent this re-traumatization of a survivor. So I think that will be an incredible episode as well. Larry, thank you so much for being my guest today. This is, as always, you are just a fountain of information and such a wonderful guest. Thank you. Thank you.
Well, thank you, Beverly, for having me, and the best of luck to everybody in your listening audience. Okay.
So to the audience, thank you for being with Larry and myself on this episode of Divorce Coalition Live. If you would like to listen to this episode again, you can find the link at divorcecoalition.com, the live show tab, or WGSN's YouTube channel, Divorce Coalition. And all of Larry's information will be available in the show notes there. We have a special gift for you, a free ebook called Stop Condoning Domestic Violence at our Divorce Coalition website under the Resources tab. Please find the Divorce Coalition at our website and like and share our Instagram at Divorce Coalition page. Join us in this fight to change a survivor's journey. We are here to help divorce professionals change the face of domestic abuse support and divorce. Let's come together and champion a brighter future. Stay tuned next Thursday at 10 a.m. Eastern for another episode of Divorce Coalition Live, improving the divorce experience for abuse survivors. Until next time, get educated, stay safe, and grow.